rise. First District Court of Appeal is now in session. All who have business before this court, draw near. Give attention and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good morning and welcome to the First District Court of Appeal. We have two cases on the docket today. We will hear them in the order that they appear. Our first case today is Florida Department of Revenue versus Jetbox Cargo Incorporated. Counsel, if you're ready, you may proceed.
May it please the court, Tim Dennis, Office of the Attorney General for the petitioner, Florida Department of Revenue. I'd like to reserve 4 minutes for rebuttal. I'd also like to note that we're only proceeding this morning on the petition for writ of prohibition. As we noted in our reply brief, the discovery order's been mooted. So,
thank you, counsel.
Thank you.
So just to be correct, counsel, you are abandoning your position to review non-final agency action. Is that correct? You are abandoning your position to review non-final agency action.
Yes, Your Honor, we are. Yes, that's been mooted. This non-rule policy challenge may not proceed on 2 grounds. The first is an issue of first impression, perhaps so obvious from the plain language of the statute. It's never been challenged in at least 10 years it's been in existence. Section 202.22 2B2 Florida statutes expressly declares that the point match database, which is what this non-rule policy challenge below involves, is not an order, rule, or policy of general applicability. Thus, any sort of rule challenge proceeding is barred by operation of law. The second basis for prohibition has long been confirmed by the courts, including this court in a similar circumstance in Department of Revenue versus Sheraton Bal Harbor. The plain language of Section 12056 Florida statute does not authorize challenge to a rule that is no longer in existence. Section 12056.4 is worded in the present tense, is forward-looking, and is intended to prevent future agency action based on a statement not adopted as a rule.
But counsel, by what authority is this court able to consider and grant a petition for writ of prohibition that seeks to determinate an administrative proceeding below based upon a lack of subject matter jurisdiction?
Your Honor, wouldn't that be this court's authority under Florida Appellate Rule 9.100 and the authority to grant writs of prohibition? Is that your question? Did I understand your question, sir?
That is correct.
Okay. Accordingly, this court should issue...
Your response is for Rule of Appellate Procedure 9.100?
Yes. This court has authority to issue writs of prohibition to lower tribunals, which is DOA, and then I believe we cited the Department of Community Affairs case where this court held that it had the authority to issue a writ to DOA.
So does DOA not have jurisdiction to determine whether this challenged action falls within the purview of 202.22?
Your Honor, I just think at this point you can just look at the language of the petition. Paragraph 74 of the petition, which is on page 15 of the appendix, clearly states, we demand we get a 0% rate in the point match database, or you have to remove everybody else's. And so I think it's clear that, and based on the other filings and the record that we've presented, that it is a challenge to point match.
Well, but that's a different question than jurisdiction. So let's take a hypothetical. If the Department of Revenue sends out a Christmas card that says Merry Christmas, all right, that's clearly not a statement of the agency. But if someone challenged that before DOA, that the department can't issue that statement, doesn't DOA still have the jurisdiction to determine whether or not that is a statement, whether that falls within the purview of, Chapter 120 and whether it's a rule or not a rule, or a statement or not a statement?
Your Honor, I think in this case, the plain language of 202.22 2B2 it leads any conclusion that on its face, if there is a challenge to information contained within the database, then that's, barred. And, we discussed substantially the reasons for that, that if if the department were forced to litigate every time somebody went before DOA, could be tied up in one, endless rulemaking, but two, subject to challenges all the time.
And I think we understand that. I think there may be a difference though between what's in the database and what, kind of constraints are placed within the database, data. So is there a difference on how the department is applying the statute, and can DOA at least determine whether, okay, the type of challenge being brought here is covered by 202, or actually, no, this is exactly what's not within that basket?
Well, I would say that we think what's clear from the record here is that it is a challenge to the information in the database. And I think based on the plain language, there might be some remedy, but the plain language that says you can't bring this kind of action would just bar the proceeding. And
why does it bar the proceeding versus, why can't the ALJ say this is dismissed because this is not, relief is not available under 120? Again, we're talking about the ALJ's ability to review this question.
Well, Your Honor, the ALJ did review this question and denied it, which is when we sought this writ of prohibition. So our position is clearly that this is a challenge to the database, and that determination is not been made correctly by the underlying tribunal. So should bring a writ of prohibition so we don't have to go through this rule challenge. So the language, order, rule, policy of general applicability, these are clearly, terms that relate to Chapter 120 and don't make sense if it's not to bar those kinds of proceedings. Now, it's important to note we're not saying there isn't any sort of relief potentially available, and that's not an issue, and the court doesn't have to decide that today. But there might be recourse to the courts or some other method under Chapter 120, but just not a 120-56 proceeding. So additionally, as a second basis for prohibition, we argue just the plain language of the statute of 120-56 itself at this point. The statutes are presumed grammatical in their construction. Section 120-56-4 is worded in the present tense. The ALJ may find that this statement is an unadopted rule, that the statement violates 120-54-1, that the remedy is entirely prospective. The agency must discontinue reliance. And this is grounded in the language of 120-56-4, but it also matches the structure of 120-56 as a whole, that it's all worded in the present tense. And here, we would contend that the record shows that it's undisputed that the key to this case is they're challenging rates that were alleged to have existed in the point match database. But as we stand here today, it's undisputed that there are no 0% rates. So therefore, there is no live statement to be challenged. This court previously ruled.
Let me go back to that, though. So an ALJ can't make that determination that, let's just take again, plain vanilla case where someone comes in to, challenge a 1966 regulation that's, been, amended 20 times. An ALJ can't decide to, that we're going to deny relief or dismiss relief because it is not, a rule in application.
Well-
Again, we're looking at the posture we're in. You're asking us for an extraordinary writ of prohibition. So
Sure.
explain why DOA can't address that question.
Sure. Well, I think in here, because it is, I think that the DOA already has addressed that question. I mean, we filed a motion to dismiss on that very point, and they denied it. And again, we think he's misconstruing the statute. And
I understand that,
they're-
but why isn't the remedy there an appeal versus an extraordinary writ?
Well, Your Honor, I think the point is because extraordinary writs are designed to protect against a tribunal exercising jurisdiction that it doesn't possess. And if there's no statement, there is no jurisdiction.
Well, let's stop again there. I mean, so does an ALJ have the authority to determine whether a rule is in effect or not? So is this, do they have jurisdiction to determine, they may get it wrong, but can they determine whether that 1966 regulation is in effect and whether they can, hear the challenge under, the Chapter 120 procedures?
I think in most instances, you would, it is true, several cases have considered that, but I don't think that that's necessarily, I don't know the posture of the other cases we've cited. Certainly DOA in these other cases, they've reached a determination that said there is no statement. We've cited the cases, WKDR2, Zimmerman, and Humane Society. But that doesn't mean that based on an argument, if the record is undisputed that there is no statement, that they should continue to exercise jurisdiction. And especially in this instance where you're combined with another statutory prohibition that clearly would seem to bar this kind of proceeding. I see I'm into my rebuttal time, so I would just like to say that I think the department's position is well-founded. The legislature's established unequivocal boundaries in 120.56.4 and 202.22.2b2. And I'll reserve.
Counsel, before you sit down, did respondent challenge the actual point match database in its petition filed below, or did it challenge the department's policies concerning the 0% sales tax rate?
Great question, Your Honor. They in their response brief attempt to pivot and say, well, we're really not challenging the point match database. We're challenging the administration of the database. But I'd say first, again, look at the petition. These rule challenges in 120.56 are grounded, in petitions that are filed with DOA. And to the extent that and go back to paragraph 74, hey, give us a 0% rate or take it away from everybody else. I think the record demonstrates that it is a challenge to ultimately the data in the database. And secondly, even the administration of the point match database, I think, would fall within the prohibition of 202.22.2b2. There is no database without data. And every decision, assuming that there's some logical decision point to put data into the database, it could equally be called a policy.
If the database no longer contains any 0% sales tax rates, what would prevent the department from creating them again at some point in the future?
Again, another great question, Your Honor. In fact, as placed in the record in this case, the legislature in 2021 came in and extensively revised Section 212.065, which addresses the sales tax rate at issue here. And so in this particular instance, I think there's no chance of that because The legislature's amended the statute, occupied the field. They've created what's called a certificate program for forwarding agents. Jetbox is one.
Again, going back to my initial question, the department filed its petitioners, Florida Department of Revenue's petition for a writ of prohibition and alternative petition to review non-final agency action. So, and alternatively, now you've abandoned your petition to review non-final agency action as it relates to the ALJ's discovery order.
Correct, Your Honor, only as it relates to the discovery order.
With that said, by what authority is this court able to consider and grant your petition for writ of prohibition that seeks to terminate an administrative proceeding only?
Well, Your Honor, I think we would say obviously to this particular rate challenge or challenge, there's no question we think the statutory bar of 202.22 2B2 is a clear statutory bar intended by the legislature to this kind of action to challenge the administration and the data in the database.
Okay, counsel, I'm going to extend your time for rebuttal to give you 3 minutes for that.
Thank you,
I'm
Your
going
Honor.
to similarly extend the time for the appellee's argument as well by 3 minutes.
Thank you.
You're welcome.
May it please the court, my name is Jeanette Maffa, and I am here today on behalf of Jetbox Cargo. The petition for writ should be denied because the Division of Administrative Hearings has clear jurisdiction pursuant to Section 120.56, Paragraph 4, to hear this unadopted rule challenge case, which is of the zip code program, not a database. The zip code program created an unlevel playing field in the freight forwarding industry by conferring exclusive benefits only upon select businesses. There are a number of disputed facts in this case. Specifically, it is disputed whether the database is challenged at all. In addition, it is disputed whether Jetbox Cargo is affected by the zip code program. At a minimum, the exercise of jurisdiction depends on these controverted facts.
But counsel, do you agree with the department that this court has the authority to grant a petition for writ of prohibition in this case if we agree with the department's arguments on the merits?
No, I believe that DOA has jurisdiction to hear this case, whether or not we're challenging a database. The Division of Administrative Hearings can decide whether this is an unadopted rule.
So they're arguing the statutory provision that says the database isn't a rule, that that statute effectively deprives DOA of jurisdiction, as I understand the argument. Can you speak to the jurisdictional issue and what relationship you think the statutory provision affects DOA's jurisdiction?
Well, I think first and foremost, Jetbox Cargo is not challenging a database. They're challenging the policy of the zip code program. And so the Division of Administrative Hearings has authority to have a fact-finding hearing and evaluate whether an unadopted rule exists. If the Division of Administrative Hearings decides that the zip code program is exclusively a challenge of the database, it has authority to determine that there is no unadopted rule or that an unadopted rule is barred by statute.
Well, so assuming that you were challenging the database, do you think that DOA would have jurisdiction to handle it, even if you were actually challenging it? I understand you're saying you're not, but even if you were, would you think that would deprive DOA of jurisdiction to handle the issue?
No, I think if the database was being challenged, and I also want to distinguish between information in the database versus the database itself, but even if the database itself was being challenged, I believe DOA has jurisdiction to determine whether or not that's an unadopted rule and would hold ultimately that it's not and it's specifically prohibited by statute.
Let's deal with the kind of stale part of this, the rules, regulations that are no longer in effect. The petitioner cites in their brief several cases, including a few cases from this court that say, when you have this, let's stick with that 1966 regulation, that's clearly not in effect. There are cases that where the appellate courts have granted extraordinary writs and granted prohibition, and found that DOA didn't have jurisdiction to determine whether that expired rule was in effect and relief was available under 120. What do you have to say about those cases?
The cases cited all went to evidentiary hearing, and also there were no disputed facts in those cases. Here, there's many disputed facts that all speak to jurisdiction, and a fact-finding hearing is needed to determine those facts.
What if the facts were undisputed? Would those cases still hold up? Is that a proper use of prohibition?
No. No, a writ of prohibition is for, as you mentioned earlier, an extraordinary circumstance. The case on point which we cited was the English versus McCrary case, and it sets out various standards for when a writ of prohibition is and is not appropriate. For example, prohibition is an extraordinary writ used to prevent an inferior tribunal from exercising jurisdiction over matters not within its jurisdiction. As I mentioned previously, Section 120.56, Paragraph 4 does provide jurisdiction. The department cited the Hillsborough County Environmental Protection Commission versus Williams case. In that case, the County Environmental Protection Commission was not an agency subject to Chapter 120. Here, it's undisputed that the Department of Revenue is an agency subject to Chapter 120. The McCrary.
So would you say that, again, with respect to this, expired, no longer in effect rule, does an administrative law judge at least have the jurisdiction to say, hear the case and say, this rule is not in effect, relief is not available under 120, and therefore, dismiss or deny relief in that case?
Yes, the ALJ has authority to evaluate a rule or unadopted rule, even if it has expired. Even in cases where the unadopted rule is moot, there are exceptions to that mootness. There's great public importance, the likelihood of reoccurrence, and collateral legal consequences. In this case, I think particularly relevant is the likelihood of reoccurrence. This is a program which has been in effect for over 10 years. So for over 10 years, the department has systematically inputted 0% rates in point match, but that's only the public manifestation of this program. They've also engaged in form-like private contracts with select businesses providing benefits, and those benefits are not even exclusive to the 0% rate in point match. In fact, you could remove the database entirely and the 0% rate from this rule challenge, and it would still be, the unadopted rule would still exist, because it is really based on
regarding the database. Mm-hmm. If the database at issue is not a rule under Section 202.22 2B2, then how can you challenge the information contained in the database as being an unadopted rule?
The database itself is not being challenged. It's the policies behind what was put inside the database. And those policies, again, are really based on the contracts. You mentioned earlier, Judge Lewis, that this petition was not just a petition for writ of prohibition, but it was also the other purpose of the petition was to prevent discovery information from being revealed. There's a related case, Department of Revenue versus International Bonded Couriers, and this court is the court that upheld an order compelling production of the documents, those same documents that are at issue in this court. So the department is now asking this court to look at only the tip of the iceberg, the 0% rate, that public manifestation of the program, and to ignore the mountain underneath that that consists of this program. Again, there's contracts. Those were the documents at issue in this case originally. They go back over 10 years. They were automatically renewable. Over the past 10 years, they've been revoked, then still renewed. 0% rates have come and gone and come again. So this program has just been going on consistently for 10 years and continues until it's repealed.
Let me take you back to this kind of mootness issue, which I think you were kind of bringing back to a little bit there. Petitioners have argued that it's undisputed that there are no 0% rates in the database anymore, and that they're not going to be in the future because of their current policy. Is that undisputed?
No, that's false. So we cannot agree or disagree to whether the rates exist in this moment, and that's the whole fundamental problem with this program, is that these contracts were secretive. It took us 2 years and this court to get those contracts, to get the full scope of this program. So we would have no idea if rates were inputted this morning, for example. You would have to go onto the Point Match website and check every single address in this state on a constant basis to know if and when these rates have been inputted. So we cannot agree at any time that they're gone. For example, with JetBox, and this program's been around for over 10 years. About 5 years ago, JetBox became aware of it because they were losing business and customers. Their competitors were advertising the rate, but that was the only way they were aware of it. This is a secretive program the departments had and maintained for over a decade. In regards to the legislation does not supplant this program by any means. It does not even mention this program in it, and the very best evidence of that is the fact that by the department's admission, they've coexisted at least for the first part of 2022. The legislation became effective January 1st, 2022, and the department's most recent admitted attempt at adjusting rates in Point Match and operating under the zip code program was in spring, I believe it was May of 2022. So for at least several months at the beginning of 2022, these programs coexisted. If the new legislation specifically prohibited the zip code program from continuing and terminated that program, there would have been no coexisting of the program.
Counsel, to some extent, you've already addressed this question, but again, how is respondent currently being harmed by policies 1 through 3 that you challenged in your petition below?
Policies 1 through 3 describe a program. At the time of filing the initial petition, again, only that tip of the iceberg was available. An unadopted rule challenge is different from a rule challenge. We have to describe the policy sufficiently, and we did so in the petition. But again, at the time, the only public manifestation of this program was that 0% rate. We also knew of times it had changed. So during certain periods of times, the department also offered 6-month valid letters of exemption, and other times they didn't. So those 3 policies in the initial petition show an evolving program, but all along during that period through today, the department has operated under this authority to engage in private contracts, to provide benefits to select businesses, and ultimately disrupt an entire industry in this state. In addition, in the English versus McCrary case, a writ of prohibition is meant to be narrow in scope, utilized only in emergencies. The department is making the argument that this entire program is moot. If that's the case, there is no emergency which would be required to issue the extraordinary writ of prohibition. In addition, there must be no other appropriate and adequate legal remedy besides the writ of prohibition.
So why would an appeal of a final order for DOA not be an adequate remedy, or would it be?
It would be. A regular appeal of a final order would absolutely be an appropriate remedy. The type of case that this remedy is appropriate for, the writ of prohibition, is something similar to what the department cited in State versus Gomez. There was the writ was granted because the case related to a sale of company assets. Once the assets are gone, there's no getting them back. I think the expression I've heard used before is the cat out of the bag. For example, if there's public information request or private information that once released, it cannot be unreleased. That's the type of case that this writ is appropriate for. It's not for a case like this where if a zip code program is deemed to be an unadopted rule, this court could overturn that ruling if DOA was wrong in their finding. Ultimately, the department's 2 arguments are both disputed facts. JetBox Cargo is not challenging a database, and the program continues to this day. For that reason alone, the petition for writ should be denied. However, the department fails to meet any of the other criteria established in English versus McCrary. There is no emergency requiring prohibition in this case, and the department's argument the case is moot further supports the lack of one. Lastly, an appeal would be an adequate remedy to an unadopted rule challenge, particularly in one in which the department claims is moot. Regardless, the basis of this writ is an argument that the zip code program at issue is in fact a database. As JetBox is not and has never been challenging a database, this court should rule consistently with the two ALJs below and this court in the Department of Revenue versus International Bonded Couriers and deny this writ of prohibition. I'd like to mention that there is a related case right now before this court, Department of Revenue versus International Bonded Couriers. I filed that in the request for judicial notice. In that case, the department also filed a petition for writ, and then subsequently after filing that petition, they filed an emergency motion to stay. In that, the department mentioned that if the emergency motion to stay was denied by this court, it would effectively deny the writ as well, because the writ is supposed to be preventative. It cannot undo something that is already done, and at the time the hearing was impending. This court went ahead and denied that emergency motion to stay, and so the International Bonded Couriers hearing has actually already happened at this point. So I'd urge this court to rule consistently with the International Bonded Couriers case and deny this writ. If there are no other questions, thank you.
Thank you, counsel.
May it please the court, I just have several issues I'll quickly address. First, to Judge Lewis's question regarding authority, I would point out, thinking about that a bit more, there's two cases, one from this court, the Sheraton Bal Harbor case, where this court issued a writ of prohibition to prohibit DOA from hearing a challenge to a rule that was no longer in existence. And the second case, the case mentioned by Appellee's Counsel, Hillsborough Environmental Commission case, there the agency was not subject to rulemaking, and I think it's the second issued the writ of prohibition there. Here we're arguing the database is not subject to rulemaking, and therefore a writ of prohibition is appropriate. Also want to clear up.
Just for you to clear up, counsel, in the Department of Revenue versus Sheraton Bal Harbor Association case, which you just referenced, was the issue of this court's jurisdiction to act on the writ of prohibition before the court, or argued before the court in that case?
I have to admit, Your Honor, I don't recall the briefs. I did look at them because they were from our agency, but I don't recall. I mean, I think it was assumed that the court had jurisdiction to make that determination. Where there's a statutory bar that's, there that says you can't challenge a rule, you can only challenge a rule when it's inexistent. Here, we've got a statute that says the database is not a rule or a policy of general applicability. I think they're very analogous. Secondly, moot. We certainly agree the case is moot, but that's not what we're arguing here today, and I understand the court might take judicial notice of that, but we're arguing subject matter jurisdiction. Policy 1, Policy 2, Policy 3, the three policies alleged. If you look at the petition itself, on its face, it says Policy 1 ended 4 years ago. Policy 2, 3 years ago. In Policy 3, although they allege, well, we don't know that there's any 0% rates, the record shows there's an affidavit from DOR saying there aren't any. It was undisputed. A petitioner below, appellee here, admitted they couldn't identify any. And in fact, referencing the other case, they did get all the information from the department after the discovery order about any 0% rates that could have existed, so they could have checked it out. And the appendix at page 95 to 97, I would ask the court to take a look at that, because there they say, look, this zip code program is used to alter rates in the point match database. So again, we think the legislature's set a clear boundary here. The language of the statute is clear. It's order. And I'll conclude. Thank you. I'm out of time.
Thank you, counsel. Thank you all. We'll give you a moment to collect your things and allow the second group of lawyers to approach for the second case. Our second case today is Patrick Fleming versus the state of Florida. Counsel, if you're ready, you may proceed.
Thank you, Chief Judge Rowe. May it please the court, Mose Bracey, on behalf of Mr. Fleming, I'd like to reserve 3 minutes for rebuttal.
So noted.
I hope to focus on the trial court's denial of Mr. Fleming's challenge for cause as to prospective juror Bennett, who's the second juror discussed in the briefs. And I hope to do so by initially briefly stating what I believe to be the crux of the appeal is, and then zeroing in on what I may refer to as the problematic comments at issue. This case is about a demanding standard of proof beyond a reasonable doubt, in effect offsetting a deferential standard of review, abuse of discretion. At a less abstract level, it's a fairly simple case. In short, the trial court's apparent conclusion that there was no reasonable chance Bennett would consider Mr. Fleming's failure to testify was itself unreasonable. And I say that for 3 main reasons. One, Ms. Bennett indicated that if Mr. Fleming failed to testify, she would consider that. She thought she would consider that failure. Prior to that, she also indicated that in essence, she'd absolutely take the stand and testify if she was accused of a crime, and basically explain why she was innocent. And then last, and I think probably most critically, she never revisited, much less recanted those views. In terms of zeroing in on the problematic comments, again, I would note that on more than one occasion, she indicated she'd absolutely take the stand and testify if she was accused of a crime that she didn't commit. She also at one point basically affirmed that she'd want to give her side of the story, what she knew to be true, and then she noted that she could have been in the wrong place and the wrong time, and something could have appeared to have been the case that in fact wasn't. So again, I think she basically had the view that she would take the stand and explain why she was innocent. And most critically, again, she indicated that if Mr. Fleming failed to testify, she thought she would consider that. And that view was never revisited, much less recanted.
Tell us what you view as the purpose of, more broadly, of voir dire. Why are we engaged in this process at all?
Yes, sir. Well, Judge Long, I think the broader purpose of voir dire is basically, from the party's point of view, to develop grounds to not only exercise cause challenges, but also peremptory challenges, to allow them to intelligently exercise those challenges.
But to what end? Might I suggest that it's for the purpose of doing the best we can to identify an impartial jury?
Yes, I think that's right, Judge. Yes, sir.
So we have these concepts, these legal concepts, the presumption of innocence, the right to remain silent. Is it fair to say that these concepts, at least in part, exist because they run against the grain of kind of human nature? That an average person might say, yeah, I'd like to hear from the defendant. If I were charged with a crime, I'd want to defend myself.
Generally speaking, yes, sir, I agree that's the case.
So can it be then that a person could feel like they would want to defend themselves if they were in the shoes of the defendant, which I think is at least partly what the question at issue here asks, that they could feel like they would want to speak on their own behalf, yet also be able to follow the law and still be a fair and impartial juror?
I certainly think that's possible, yes. Now, I don't think that's what the case is here, but yes, sir, I do agree that that can happen.
Okay.
Yes, sir. And if I could elaborate on that, I would say a couple of things. Judge Long, I think one, I think a key focus here is that at the time Ms. Bennett expressed what I'm referring to as these problematic views, she had been repeatedly instructed more or less on the relevant law. I think that in the words of the Florida Supreme Court's Matterance case, she had developed the requisite familiarity with the judicial process. And prior to
I don't know that the transcript really bears that out. So let's go back to the defense counsel's question to Ms. Bennett, and he asked her, who would absolutely take the stand and testify? And then she answered, so you would absolutely want to testify? I would, says Ms. Bennett. So you would absolutely get on that stand and testify. And it continues until the point where then she's asked, if Mr. Fleming decides not to testify, that's something that you would consider? And she says, I don't watch a lot of court shows. I don't know a lot about the law, so I didn't even know that was allowed. And then it seems like as she became educated, it's a different understanding. I think she didn't come in understanding perfectly that right not to testify. So I guess, reading from there, help me understand how it's very clear Ms. Bennett would want to testify, but at the same time, it's not clear to me that she's not able to not hold that against Mr. Fleming should he choose not to take the stand.
Yes, ma'am. Well, a couple of different things, Chief Judge Rowe. One, before kind of delving into the specifics there, I do just kind of want to emphasize that the standard here is a very demanding standard, a reasonable doubt. And so basically, if all reasonable people would think that there was just one non-speculative doubt, then I would say Mr. Fleming would prevail on appeal. But to delve a little deeper into the transcript, and just so I'm clear, Judge, I think we're on page 272 through 273. And so
beginning at 269 and 70,
ma'am.
and then proceeding to 272 and 73.
Right.
Correct.
And so just to kind of track through that, the defense does ask that general question, who would want to absolutely testify?
A very emphatic question, right? Not kind of an open-ended who would want, but who would absolutely take the stand and testify? Says that 3 times, right?
Well, but I would argue, Judge, that actually weighs in Mr. Fleming's own appeal because Ms. Bennett, agreed with a very strong statement. Absolutely, not maybe.
As to herself, right? But then,
Yes, ma'am.
then when she's educated on the law, she has a different answer, does she not?
Well, I don't think so. No, ma'am. I think that on page 272, the defense counsel says, what about you, Mr. Turner, another juror, knowing that you said you would absolutely get on that stand and testify if he decides not to, is that something you would consider? Yes. Okay, Ms. Bennett, what about you? Yeah, I think so. Which I would argue she's saying, I think I would. Now, she does then, when the defense counsel says, yes, you would consider if Mr. Fleming decides not to testify in this case, that's something you would consider. I want to be honest, I don't watch a lot of court shows. I don't know a lot about the law, so I didn't even know that was allowed. And then she says, I thought both people had to present a case, so that's a little surprising to me.
Correct.
Now, the way I read that, Judge, is that at this point in time, she is not revisiting or recanting what she had just said, that she thought she would consider a failure to testify. She's basically saying, prior to coming into jury selection, prior to learning what the law is, I thought both people had to present a case. I'm surprised to realize the defendant doesn't have to testify, but
I think that goes to Judge Long's point. I mean, a lot of these principles run against the grain of common sense, correct?
Yes,
and
ma'am.
so when you're asking her what she would do, and then you're pivoting to, here's what the law requires, she's providing a different, certainly less emphatic answer, right? You at least concede that.
I think she's explaining why she's surprised to have learned prior to saying, yes, I think I would, and I would take the stand.
Okay, I think I understand your argument.
Yes, ma'am, and I would
But
also
you would
go on-
agree that many of these prospective jurors arrive not knowing the judicial processes and procedures.
Yes, sir, generally speaking, yes, sir. But I think what I would want to kind of emphasize on this point, because I certainly acknowledge the points that are being made. Again, I think the key question here is, would any doubt, would any belief that Ms. Bennett may consider Mr. Fleming's failure to testify, is that pure speculation? And I would argue that on this record, particularly when the view was never really revisited and no attempt at rehabilitation was made, that doubt is not pure speculation. It's not imaginary. It's not forced. The other thing that I think is worth pointing out is that, certainly the trial judge here has the advantage of being in the courtroom and seeing how the jurors, their demeanor, their tone of voice. But as the Florida Supreme Court has recognized, I believe, in Cop Show, here the judge just summarily denied the cause challenge. He didn't make any findings. And so in those circumstances, as I read the Cop Show opinion, this court is entitled to rely on the responses as they appear from the record. Unfortunately, we don't have any insight into the candor or relative certainty with which Ms. Bennett responded.
But to that point, let's look at we're all looking at the cold transcript, right?
Yes, sir.
And your suggestion that there is some reasonable doubt. If, in this case, prospective juror Bennett holds this a belief that she would testify or that she would want to defend herself, does that mean, from what we're looking here, can we fairly read this to conclude that she would then not follow the law as instructed by the court?
I think that there is at least a reasonable chance that she would not, Judge Long. I think it's a non-speculative doubt that she would fail to do that, or a non-speculative doubt that she would do that. And I say that again because, she says, yes, I think I would consider the failure to testify, and that's after, I believe, on at least 3 occasions, the judge has basically said, the defense doesn't have to present evidence or prove anything, and the defense on at least a couple of occasions has reemphasized that to the jurors. And I guess I would take the position that with respect to Ms. Bennett, she just never really revisited or recanted those views. But even if we assume that, say, her last answer, was in tension with the prior comments, I would just point out that under this strict standard of proof, even when we factor this deferential standard review on top of that let's assume all reasonable people could find some reasons to believe that she would, in fact, do her job, set aside her views and follow the law. As long as all reasonable people would also find at least one non-speculative reason to think that she may not, then I would say Mr. Fleming would prevail on appeal. And if I could just make 2 last points before possibly reserving the balance of my time for rebuttal, I think Florida law is pretty clear that ambiguities and uncertainties are to be resolved in favor of excusal. Similarly, close cases are to be resolved in favor of excusal. So I do think those would weigh in Mr. Fleming's favor here, and I'd be happy to answer any further questions. If not, I'd ask to reserve the balance of my time.
Okay, thank you, counsel.
Thank you.
May it please the court, my name is David Welch. I'm with the Attorney General's office, and I represent the state of Florida in this case. It's the state's position that the trial court made the correct decision in denying both challenges for cause in this case. I believe it's from the Lusk case where it's that appellant is not entitled to a jury completely free of any bias or prejudice. Such a jury would be impossible to assemble. The test for juror competency is if a juror can lay aside any bias or prejudice and render a verdict solely on the evidence presented and the instructions on law given by the court. And so it comes down to, does the juror have the proper state of mind that would prevent the juror from acting with impartiality? And in this case, neither juror gave any evidence that they would not be able to act in impartiality. I think, as your honors has already kind of hit on, the main question that they answered was, what would you do in a hypothetical situation where you were wrongfully accused of a crime? that's a halfway decent primer question potentially to get into other questions, but it's not itself entirely relevant to, okay, now that we know what you would do if we hypothetically wrongfully accuse you, but does that mean you would have a negative opinion about the defendant in this case? And in that instance, neither juror ever said that they would require the defendant to present evidence or that they would be negatively influenced against the defendant from testifying. The closest we got is after that loaded question of, these are lay people coming into court. Hey, person who's not potentially familiar with the law, if I wrongfully accuse you of a crime, are you going to want to defend yourself? I would argue that the majority of people are going to say, yes, I would obviously defend myself. And it's like, well, why would you defend yourself? Well, I want to put my side of the story on it. And I think that's kind of the realm where we're at, where it's like in a perfect world, yes, you would want to hear from the defendant. And I think every jury who's ever gone back to deliberate who hasn't had the defendant testify in the back of their mind are saying to themselves, I kind of wish we did have the whole story. It would maybe make our decision a little easier. That doesn't necessarily mean I'm going to hold it against the defendant that they didn't testify. And
in fact, a juror could think that during deliberation, right?
Yes.
I mean, is there anything that in the law that would prohibit a juror seated in the jury room from thinking, well, before I convict someone, I'd love to hear from them, but the law is I have to review the evidence that's before me, and I can only consider the things that the judge told me that we can consider.
Yes,
and then move
yes,
on
Your
to
Honor.
follow the law.
And I think that goes to my the point I earlier made, that the law is you cannot have a negative inference from the defendant not testifying. The law isn't that you're not allowed to acknowledge that the defendant didn't testify. In fact, by the time you get to the jury deliberation, it's been beat over your head between voir dire and then the instructions that, hey, the defendant didn't testify, you're not allowed to consider that negatively against him. Well, when they get back there and they review the evidence, they're going to think, okay, well, we heard this, this, and this. I would have preferred if we had also heard about this, this, and this, the holes in either the state's case or the defense case. And, in a lot of crimes, there's going to be potentially only, a specific number of eyewitnesses, one of which would be, in theory, the person who actually committed the crime. God, I wish we'd heard from the defendant to hear if he could have explained some of these theories or holes in the state case. And I think it was Juror James, too, who's like, when she was asked, well, would you consider it, about the defendant testifying? She's like, well, I guess it depends on the evidence. And I think that's a perfectly logical point of view to have, that, if the evidence is overwhelming against the defendant, you can go back and be like, man, so much evidence against him. I wonder why he didn't want to take the stand and testify. But again, those are hypotheticals. And one of the main issues in this case, too, is no one ever defines what consider means. Look at this compared to some of the cases where they have overturned the refusals, like Overton, for an example, where you have a juror saying, I can absolutely follow the law, but in the back of my mind, I'm still thinking to myself, he didn't testify, he has something to hide. So that's an ambiguous answer where you're saying, yes, I could absolutely set aside my bias saying I'm following the law, but at the same time, I'm also telling you I'm going to be thinking, I think that this person has something to hide. Here it was, again, it was a leading question from the during voir dire. What would you do if you were wrongfully accused from a crime? Well, I'd want to defend myself. Okay, well, would you consider the fact that the defendant didn't take the stand? Yeah, I would consider it. Doesn't mean that I would have a negative influence from it. It would just be, I would consider it. And then when you look at their answers as a whole, every time they say, hey, you have no evidence presented to you, what does that mean? It means the defendant is innocent. Do you understand it's the burden of the state to prove that the defendant is guilty? Yes, we understand that it's the state's burden to put on evidence. Nothing in their answers gives them the indication that they would take a negative stance against the defendant if he did not testify. Looking at some of the other cases, Koso, I apologize for my pronunciation. You have a juror who said, I would have a difficult time returning a verdict without hearing from the defendant, and that the juror responded that they thought the defendant should have to testify and that they didn't know if they could set aside that view. And I think that was the case where the juror said, at the end of the day, we all have to stand in front of our maker, innocent or not, and stand for judgment, and that the law should be the same thing. Well, that's a juror who's got a strongly held personal belief that I think the defendant has to take the stand if they're innocent or not. That's a juror requiring the defendant to take a stand. Here, no one said, there was no indication that they would require this defendant to take the stand. There's no indication that they would have a negative inference from the defendant failing to take the stand. The majority of the questioning was, again, what they would do in a hypothetical situation of being wrongfully accused. The defense attorney never actually followed up to clarify, okay, now that you've said I would take the stand, I would consider that against the defendant. It could have easily been a question of, all right, you said you would consider that. Does that mean you would have a negative inference or not? That question was never asked. The only evidence we have in front of us is that they said that they could follow the law, that the defendant was not required to take the stand, and that they understood it was the state's burden to put on evidence.
The statement, I thought both people had to present a case, so that's a little surprising to me. Would it be fair to read that as implying that now she has learned and understands that they do not, in fact, the defendant does not have to present a case?
Yes, Your Honor. In that case, it's actually, I think it's almost the case of a defendant, a potential juror rehabilitating herself in real time. She says, I don't watch a lot of court shows, but, in theory, if this is a person who's maybe only seeing like a Judge Judy type show or People's Court, where you're watching it and the judge is up there firing rapid fire questions and requiring both sides to respond, you might go into the impression like, okay, I want to hear from both sides, I'm going to hear from both sides, and if one side just refuses to answer the question, well, that's weird. But now she's basically saying, hey, I acknowledge, I didn't realize beforehand that the defendant wasn't even required to do that. And I would argue that, she's rehabilitated herself, and when she gets back into the deliberations, she's going to think about the fact like, yeah, I didn't hear from the defendant because that's something I thought that beforehand that you had to do. She's considering that, that's considering it. That doesn't mean I'm now holding a negative inference against him or her, as the case may be. But again, the law isn't, you're not allowed to go back to the jury room and never think about the fact that the defendant did not testify. It's that you're not allowed to require the defendant to testify or draw a negative inference from the defendant failing to testify. And none of the answers given by the jurors in this case would lead a judge in this case to believe that these potential jurors would take that negative inference. And if there are no further questions, for the reasons stated today and in our brief, the state would ask that this court uphold the appellant's convictions and sentence.
Thank you, counsel.
Just very briefly, I would suggest that, with all due respect, the state is essentially offering some speculative reasons to think that Ms. Bennett could do her job. To suggest that she self-rehabilitated herself and that when she got back to the jury room, she would, wonder why the defendant didn't testify but not account for it. There is no evidence in the record to indicate that. That's just presuming that fact.
Well, but isn't that really sort of the human instinct that the law doesn't require them to stop being human beings, right? They're going to be sitting in the courtroom. They're going to see that the defendant doesn't testify or that the defendant doesn't present a case, and the law doesn't require them to close their eyes to reality. They'll see that, and they might wonder why that happened, but at the same time, and it might be natural for them to wonder why they made that decision. But at the same time, we also expect jurors to follow the law and presume that they do. So why would we not, under this circumstance, presume that they did in fact follow the law and not punish the defendant for not presenting a case or not testifying?
Well, Judge Long, I think that jurors are presumed to follow the law once they're sworn in and, make a decision, but I'm not aware of like everyday prospective jurors coming in and there being a presumption that, they're going to follow the law. I think that's what voir dire is for. And here, even if the comments she made could have been solidified more, the reality is they were not revisited or recanted, and I believe they provide at least a non-speculative reason to doubt. Really what this comes down to for me is the beyond a reasonable doubt standard of proof is just so demanding. And if I could just briefly say just a few things, no rehabilitation was even attempted. It would have been so easy to circle back and just, ask some follow-up questions there. And I would note that, under Florida law, a juror cannot be influenced in any way by a defendant's failure to testify, including viewing it as an admission of guilt. So it's just the law also is very demanding there. And then finally, as far as what did consider mean, what did I think both sides should present a case, was that, saying she now understood ambiguities and uncertainties as well as close cases are to be resolved in favor of excusal. So in conclusion, I would just say the beyond a reasonable doubt standard is demanding. If there's just one non-speculative doubt, then that standard is not met.
Counsel?
Yes, sir.
Okay, before you sit down, looking at there's been a statement where she said, I want to be honest, I don't watch a lot of court shows. I don't know a lot about the law. So I didn't even know that was allowed. Ms. Berg says, okay. Ms. Bennett says, I thought both people had to present a case. So that's a little surprising to me, what she thought. Why wasn't it incumbent upon Ms. Berg to follow up with another question?
Yes, sir.
To Ms. Bennett?
Yes, sir.
But Ms. Berg didn't do that.
Well, Judge,
A question specific to this case.
yes, sir.
Would Ms. Bennett follow the law?
Yes, sir. Well, what I would say there, Judge Lewis, is that, if that question would have been asked, depending on the answer, her view that she would consider a failure to testify could have been solidified further. Now, that question was not asked. Nonetheless, there's still a non-speculative reason to doubt. And I would also emphasize that clearly, as I understand Florida law, the defense has no obligation to rehabilitate a juror. That's up to the judge and the court. So while I would like to be able to tell you there was a follow-up question, she reaffirmed her view, that's not the case. Nonetheless, I would again come back to there's a non-speculative reason to doubt. There was a non-speculative reason to be concerned that she would consider a defendant's failure to testify, even though that view could have, in theory, been solidified more. And I just think this is a rare case in which the trial court abused its discretion. We'd ask you to reverse Mr. Fleming's conviction and remand for a new trial. Thank you.
Thank you, counsel. Thank you both. This court is adjourned.